Well, at this point, you may as well just
Throw out the jury questionnaire.
Viva Frei, Montreal litigator turned YouTuber, and this is Winnie the Westie. It's been a while since I've done a car vlog. In fact, the last time I did a car vlog, this is what I looked like. Well, we have officially gone beyond the realm of judicial activism. We have entered the realm of
Judicial heroism.
Since the Ottawa convoys, this channel has taken a turn towards the live streaming, and I've got to say I love the live streaming even a little bit more because it gives you the time to put the nuance into videos, to respond to questions, but every now and again I'm going to put out a car vlog because it's a Saturday, I have a few minutes, and the Ghislaine Maxwell trial, well, there's been an update in that. Now, for those of you who may have been living under a judicial rock for whatever the reason, the Ghislaine Maxwell trial, we were all covering the Ghislaine Maxwell trial at the time. There was Inner City Press, Good Logic Joe Neerman covering the trial. It was one of the most prominent trials in recent memory, and Ghislaine Maxwell in a trial that was nice and neat, tied off and sent to the cleaner. I don't even know what that means. It was ended in the perfect manner possible in that Ghislaine Maxwell was found guilty on 5 of the 6 charges. No serious evidence was disclosed to the public, and everything was just wrapped up nice and neat.
Well, isn't that convenient for you?
Now, full disclosure, make of it what you will. I do believe that Ghislaine Maxwell was indeed very guilty. The only problem is I think a lot of other people were also very guilty, if not guiltier. But the way this trial was conducted, a lot of information was kept secret. A lot of documents were redacted. The general public got no more information than they absolutely needed in order to come to the conclusion that Ghislaine Maxwell and no one else was guilty in the context of this ring. And that's how it ended.
Surely you can't be serious.
I am serious. And don't call me Shirley.
That's how it ended. Ghislaine Maxwell promised to appeal her conviction by jury. That's how it ended until one of the jurors, juror number 50, went around doing some interviews after the conviction and revealed to the general public that he himself was a victim of the very issue that was at the heart of this trial. That is to say, assault of a certain nature when he was a child.
On the stand, David acknowledged he had been sexually assaulted by his stepbrother as a child, but indicated on his juror questionnaire that he had never been sexually abused.
This juror number 50 went and did public interviews in which he disclosed this very fact. The only problem is that this was one of the questions on the juror questionnaire, which this juror member answered
no.
Now, why would this be such a big issue? Well, 5 of the 6 charges on which Ghislaine Maxwell was convicted had a very certain specific nature to the assault, which was central to this case, which is why it was on the jury questionnaire. It was one of the more important questions on the juror questionnaire, and apparently this juror somehow forgot to answer that question in the affirmative. And what was this juror's explanation for how he answered this question wrong?
On Tuesday, David told federal judge Allison Nathan that he, quote, flew through the questionnaire and was super distracted while filling it out in a noisy room.
That's right. This juror, in the context of a trial where assault of a very specific nature is central to the prosecution itself, in fact, so much so that if you go to Wikipedia and see what Ghislaine Maxwell's occupation is described at, it is described as this. That's right, in the context of one of the most highly publicized criminal prosecutions of recent memory involving the biggest names of the biggest names, this juror, when filling out his questionnaire, said, I was distracted, I was whizzing through the questionnaire, and I forgot to answer one very important question in the affirmative. Well, Ghislaine Maxwell, who promised to appeal the conviction for a number of other reasons, some of which might have a basis in law, found another reason to appeal this decision on the basis that this juror basically lied on the questionnaire and tainted the entire process itself.
Filing points to a Supreme Court ruling that allows a defendant to have a new trial if they can show a juror failed to honestly answer a material question for the court.
Now, in law, in order to overturn a jury conviction and order a new trial because of misinformation that a juror provided in the context of jury selection, the misinformation doesn't just have to be misinformation. It's an extremely high threshold to overcome. It has to be an overt, deliberate lie. It would have to be an overt, deliberate lie that would have resulted in that juror getting struck immediately for cause. It had to have an impact on the deliberation process itself. In other words, it's a very, very high threshold to overcome, but Ghislaine Maxwell filed an appeal on that basis, and this was argued before the judge of the case, Judge Nathan. In the context of this motion to overturn the conviction and order a new trial, Judge Nathan determined they would not be hearing from any of the other jury members. They would hear only from juror number 50 because that testimony alone is the only relevant testimony to the process. Agree or disagree with that determination as you will. They heard from juror 50, and how do you think the court came down in this case? Would Judge Nathan, a judge that was recently confirmed to the Court of Appeal in a trial involving some of the biggest names on earth that wrapped up nice and neatly with a conviction and not involving any other big names on earth, would this judge find a way to overturn that conviction, order a new trial with all the risks and perils that would entail? I think you all know the answer, because the answer is
No, never.
Ghislaine Maxwell's bid for a new trial as a result of what many people would probably rightly conclude was a very material omission or very material misrepresentation on the jury questionnaire. The judge came to the conclusion that no, you're not getting a new trial, and this is the judge's rationale for that. From another YouTube lawyer, Emily D. Baker's Twitter feed, @TheEmilyBaker. Maxwell dismissal denied. In today's ruling denying the motion for new trial, quote, the court concludes that Juror 50 testified credibly and truthfully at the post-trial hearing. His failure to disclose his prior SA, which stands for assault of a very specific nature, during the jury selection process was highly unfortunate, but not deliberate. The court further concludes that Juror 50 harbored no bias toward the defendant and could serve as a fair and impartial juror. The requirements for a new trial under McDonough are not satisfied. The defendant's motion for a new trial pursuant to Rule 33 is therefore denied. End quote.
Denied.
This ruling will likely be appealed by Maxwell, but she will move forward to sentencing as the court also ordered the pre-sentence report and affirmed the June 28, 2022 sentencing date. Judge Nathan came to the conclusion that this particular Juror 50, who wrongly answered a question on the jury questionnaire, no, I had not previously been a victim of a certain specific type of assault, could be an unbiased juror, despite the juror himself saying this to The Independent. Quote, this verdict is for all the victims, end quote, David told The Independent. Quote, for those who testified, for those who came forward, and for those who haven't come forward. I'm glad that Maxwell has been held accountable, end quote. And at the risk of asking a question to which I suspect I know the answer for a great many of you, how do you feel about this particular verdict? Setting aside whether or not you think Ghislaine Maxwell is guilty and deserves to be sentenced, how do you feel about this particular judgment? If failing to answer a question of this importance on a jury questionnaire is not cause for a retrial, what type of misrepresentation on a going forward basis is going to be sufficient for a retrial?
David, known as juror number 50, says other jurors voiced doubt about some of the accusers.
Some people were like, how could they keep going back? Like, why would their moms allow them to do that? And I was like, we can't judge them based on what they did or didn't do. They're 14. They don't really have the wherewithal to know really what's right and wrong.
And for those of you out there who feel that Ghislaine Maxwell is in fact guilty and in fact was rightly convicted, but feel that there are a lot of other people out there who got off scot-free, I know you would have loved to have seen a new trial with a little more exposure, a little more unredacted documentation, so we could find out
Who was really behind all of this ring?
But alas, as I have said many times on this channel, and as I will say many times more, at the end of the day, the only opinion that matters is the opinion of the judge. And for those of you who are new to the channel, I have this main channel and my Viva Clips channel where I post clips from the live streams. If you like my content, you know what to do. Like, share, subscribe, hit the notification bell. Robert Barnes and I do weekly live streams every Sunday. We do weekly streams with a guest every Wednesday. I have been pretty much doing live streams daily, and I will continue to do those. If you want to follow Robert Barnes and me on Locals, you know where to find us at.
Oh, man, one of these days I'll get this right. There we go. VivaBarnesLaw.locals.com.
All of my content is on Rumble as well, and on Rumble you can find a neat little widget which will bring you directly to our Locals page if you are so inclined. But more important than anything, take care of yourselves, check in on friends and family, make sure everyone around you is doing well, and now you know your vlog. Peace out.